Very good morning. The permanent president of the SCBA and SCORA, Mr. Praveen Parekh. A very distinguished sister from Nepal, from the Supreme Court of Nepal, Justice Sapna Pradhan Malla. Vipin Nair, Nikhil, Amit Sharma, my dear friend Sushant Nadkarni. I don't know him as Atmaram Nadkarni, but as Sushant really, since we were members of the bar. All the very distinguished senior advocates, but above all, my very dear brothers who are present here this morning, who have come from Delhi all the way. Each of them is a distinguished colleague with a wealth of experience. Prasanna Varale, Prashant Bhai, Mishra, Bindal Saab, and Sanjay Karol, all dear friends on the bench. And of course, Koteshwar, whom I call Koti. In fact, every morning when we meet each other in the lounge, judges also have their camaraderie. So I always bow to him and say, Koti Koti Pranam. So you see, we are a very small family of judges, and one thing which I have done during the course of my last 2 years is nobody is called brother and sister. We all call each other by their first names. For some reason, somebody becomes Saab, like Bindal Saab becomes Bindal Saab, you know. The chairperson of the Bar Council of India is here, Manan Kumar Mishra ji, who is our newest entrant to the parliament. Members of this SCBI here, Vikrant Yadav. I don't see Mr. Kapil Sibal, but of course, so many senior advocates who are all present here this morning. As you saw, when I got up without a scrap of paper. I do have a prepared speech, but I said this is not an occasion to deliver a prepared speech on a Saturday morning at the conference of our dear family of the Advocates on Record. I thought I must begin with the last topic first, which is law and humor. There was a particular reason why I thought I should do that, because initially when I came, only the first 2 or 3 rows were full. And I realized in Goa, people are sauntering in a little late. I would have done that myself, but I had to keep to schedule. But I spent about an hour and a half this morning walking the entire length and breadth of the Miramar beach, something which I do when I stay in Goa, whether I'm staying at the Marriott or not. And I walked from Miramar all the way to Dona Paula and came back. Law and humor. I've learned so much from the seniors at the bar from whom we have imbibed all the lessons of life. I was once traveling with Praveen Bhai from Delhi to Mumbai as a young lawyer. And we were working on this very complex case involving the then Monopolies and Restrictive Trade Practices Commission. And as we were driving down to the Oberoi in Mumbai at Nariman Point, Praveen Bhai and I were sharing one room because the client thought that, they can't afford to have me put up in a separate room. I was not well worth the client's expense. But Praveen Bhai was very gracious and he said that, well, I'll allow you to shack up in my room. So after, we had finished all the conferences and everything for the day, I learned some of life's lessons from Praveen Bhai. One of the lessons which he taught me was, he says, irrespective of how much your client pays you for a matter, when you're going out of station, please remember you must stay in a 5-star hotel. So I said to Praveen Bhai, why is that? He says, how people assess you is far more important than what actually is the position about your practice. So when you stay in a 5-star hotel, your other clients will say, this is a 5-star lawyer. So many of life's lessons from the greats whom we have, when we have interacted with. I remember sitting in the Supreme Court Bar Association with Mr. Jetmalani on the side, and so many of Mr. Nariman used to come in and go out. Dr. Chitle used to be on the other side. Perhaps I'm one of those lawyers and judges now. I've been around since 1982, where my career has straddled the tradition and, of course, the new. I remember Ram sitting down, and an advocate on record coming and asking him, Sir, a criminal appeal argue karna hai, par bahut zyada accused hai. There are many accused in this matter, but you have to argue this criminal appeal. It's a very sensitive appeal which has come from Punjab. So he was asked by the AOR, Sir, but what would be the fee? So Ram sort of looks into thin air and then says, Beta, aisa kar do, ek peti bhej do. I don't know what ek peti meant in those days and what ek peti means today. You will have to take a call because you're going to be discussing the Prevention of Money Laundering Act. But Ram, I was sitting just next to Mr. Jetmalani because I was to brief him on an SLP which was drafted by his very gracious daughter who was to give me a lot of work. So he looked at me and realized that I was quite flummoxed as a young lawyer with this concept of the fee which he was quoting. So he looked at me and said, Beta, you know what? People always focus on the exorbitant fees which I charge some lawyers and some clients. But he says, what they forget is that I subsidize the few people from whom I charge these enormous amounts with the large number of people for whom I appear free of charge. And the great illustration was when he appeared for one of the assassins in the Prime Minister's assassination case. When he was told that, well, this may be not consistent with your being a member of the Parliament, he says, I'll resign, but I have to do my duty as a member of the bar. He eventually got an acquittal in one case of a person who was sentenced to death, perhaps. So that's the great tradition of our bar, this sense of fearlessness, the sense of independence. And that's, I think, why the Supreme Court bar continues to flourish and thrive as the sentinel on the movement for the preservation of fundamental rights. So in a sense, it's rather important that we are discussing crucial issues which concern our polity, our nation, in the course of this day-long conference. We are beginning with the transformative role of the Constitution, going into areas of environmental law, then arbitration law, and then finally, of course, wrapping it up with ijaz and law and humor. And there is so much more to law than the dry pages which we speak about. There's a lot of humor going on in the judiciary as well, because when we are about to enter court and get into the stress of the day, you require some equalizing force, some force to keep you rooted. We used to have a very interesting tradition a few years ago when Chief Justice Deepak Mishra was the Chief Justice of India. He would walk in at about 10:20 and all of us were there in fits and starts between 10 and 10:20. And he would come and stand next to Justice Nariman. And he would ask Rohinton a completely abstract question. All of us sitting next to Rohinton would not know a clue on what that question meant because it was completely rhetorical. And Rohinton would respond to Justice Deepak Mishra in a completely rhetorical sense. And we wouldn't know what the answer was as well. So I would turn to Rohinton and said, what did you mean by that? So he says, God knows. And then I would say, but you answered a question of the Chief Justice. He says, I didn't know what the question was, so I thought I should answer in a manner which nobody knows the answer. I hope none of you tries to do that in the court. To the best of my knowledge, you have not. Sometimes that is done as well in court. The other day I had you have so many experiences. I could write a book on these experiences now that, that the cycle of life is now moving on in my life to a new chapter. The other day, a young member of the bar came to me and in the court in the morning and said, I'm mentioning a case for correction in one of your orders. So I said, what is the correction? Normally lawyers come and mention, that my appearance is not shown. I'm very liberal because that means he wants to get his fee from the client. And I always say, why should I go into whether that lawyer, really young junior, appeared or didn't appear? If it's going to help somebody's career, one more appearance or whatever, it doesn't matter for me, so long as, the work is done in the court. So he said, at the end of your order in a Section 11 Arbitration Act case, when you made a reference to arbitration, you had dictated that all the rights and contentions of the parties on the question of jurisdiction are kept open. But when we saw the order, it doesn't contain it doesn't say that. So I said, it's very unlikely that I would have dictated this because I never issue a clarification. That's one thing which I have learned as a mantra. I never issue a clarification which is implicit in the order. A clarification has to be given in an order, provided absent that clarification, there would be a cause of ambiguity. If there is no question of ambiguity, usually lawyers, as you know, advocates on record ask you for that little clarification to tell the client, see, I got you this. So even if this SLP dismissed, I got you this. Request the High Court to dispose of the case in 3 months is one of those mantras which we used to ask when we were young lawyers. So I said, I'm sure I never put this in my order. And then he looks at me very seriously and says, your courtmaster has taken down the transcription and this is there in his courtmaster's the stenographer's book that you have dictated this order. At which point of time I really lost my shirt and I felt really bad at it because, you go back home and you reflect on what's happened. And I've never really got angry with juniors. And I thought that, I was unduly harsh on that junior. So when I went home, I shared it with my spouse, who's really a great sounding board for me. And she says, you're completely wrong. You shouldn't have been harsh to this junior. And she also said that, look, you should have explained to him why you have not put this in. But I said, in the heat of the moment, when, you have a board of 70 or 80 cases, you have no time to do all this explanation. But the reason why I of course asked my courtmaster, did I dictate this? And is it that you deleted it or I deleted it later on? He says, no, sir, it was not there in the original order which was dictated. And I don't know where he got this from because we never share what the judge has dictated and which we take down in our stenographer's book because until you sign the order, it's not final. But then as judges, you always feel the sense of regret when you are harsh on a young member of the bar because I do believe that it's part of our obligation to encourage and we've all made mistakes. Another life learning experience which I learned from another senior like Mr. Parekh was while mentioning a matter in court when I didn't have a scrap of paper. I was a young lawyer in Bombay and a very well-to-do, respectable Gujarati senior came to me and said, Dikra, Dikra in Gujarati means young man or really child. He said, Dikra, never mention a matter in court without any paper in hand. You may have even a wrong paper before the judge, but always have a paper in your hand so that the judge feels that you are ready with the case, We are here to really celebrate the 75 years of the Supreme Court of India. And I'm really delighted that the Advocates on Record Association has put together this conference because celebrating 75 years of the Supreme Court is not really something only for the judges. We have adopted many, many initiatives in the course of celebrating the 75 years of the Supreme Court. We began with an inaugural last year, and now we have launched huge number of initiatives. As you know, we are on the anvil of constructing a new building for the Supreme Court of India because I felt that we have received this building as a heritage from those who came here before us. And what do we leave behind for posterity? And the idea of the new building is to create 29 new courts. The bar is now expanded. As we see, Sister Sapna, you would see so many women lawyers here who are present. That reflects the changing demographics of our nation and our profession. And we need to create new spaces for particularly the women lawyers who must have places to rest, relax, read, reflect, and meditate on what they are going to argue. Good library spaces, though we are, of course, going virtual. So this is really one of the key initiatives that we have adopted. We did a lot in terms of technology, whether it is in terms of launching e-filing of cases, the digitization of case records, the conversion of constitutional bench arguments from speech to text immediately, live streaming of our court proceedings. I think live streaming of our court proceedings has been a game changer, despite the flip sides. And all of you would have seen some of the flip sides in the last few days. There are lawyers who speak to the gallery, judges who may not exactly be alive to the fact that what you are speaking in court is now not within the confines of this particular courtroom of 25 or 30 or 50 lawyers, but it goes to 20 million people almost at the flick of a button. So we have to, in that sense, train our own consciences and our own etiquette into understanding how we address the bar and how the bar should be addressing the court. So we do have some grandstanding by lawyers, but by and large, I always feel, and that's been my mantra, that we must always live on a sense of hope, not on never live on a sense of cynicism. You'll always have people who will try to misuse the system, but institutions cannot be founded on the assumption that somebody will misuse the system, but on the good faith that everybody will be in it together for the betterment of the community. And I do believe that live streaming is something which has taken the work of the Supreme Court of India to the homes and the hearts of people. It's enabled society to have a wider critique on the functioning of our court. Too very often, a perception gains ground that the Supreme Court does cases only involving the rich and the resourced clients. And it's very easy to make that allegation against the Supreme Court, because who knows who has the ability to come and cross-check what you are doing. Citizens are outside the system. But live streaming has changed all that, because citizens now know that the smallest problems of citizens, whether it's a small bail application of someone who is seriously suffering from an ailment and is in custody for 2 years under the PMLA or under the NDPS, or somebody's pension, somebody's service retirement dues, that all these ordinary problems of simple human beings get the most serious attention of the Supreme Court. Now, one way of looking at it is, should the Supreme Court be dealing with these small matters that we deal with? My take is very different. And that's something which I think is important in the perspective of the first topic which we are going to discuss. Unlike, say, some of the Supreme Courts which were constituted globally, like the American Supreme Court or the UK Supreme Court or the Australian High Court or the South African Constitutional Court, the Supreme Court of India was modeled on a completely different paradigm. And that paradigm was of the access to justice, because essentially it was a Supreme Court which was created in 1950 to deal with the problems of a poor society. We are a less poor society and a more affluent society, a society which is now rapidly growing into economic growth and development, but which still has pockets of underdevelopment. So the role of the Supreme Court is not just as a final arbiter of constitutional disputes and doctrine, but also as a socially transformative instrument. And that social transformation that the Supreme Court is intended to bring about does not come in only in the case of seminal issues which we have to decide, but also in the small issues which we decide from day to day, in which we give, in that sense, a guidance to the nation, to the high courts, to the district courts. Because when we stand firm on some issues, that provides a guidance to the district courts, to the high courts, that if the Supreme Court has given us this cue, surely we have to now follow in that path. So in that sense, the access to justice paradigm of the Supreme Court, which has been developed over the last 75 years, is something which we should never lose track of. Otherwise, as societies grow and societies evolve into more prosperity and affluence, there is a perception that you should be looking at only the big ticket items. Ours is not a court like that. Ours is a court which is a people's court. And I think the role of the Supreme Court as a people's court must, of course, be preserved for the future. Now, being a people's court is not to say that we fulfill the role of the opposition in Parliament. I think there is, particularly in today's times, there is this great divide between everybody who thinks that the Supreme Court is a wonderful institution when you decide in their favor. It is an institution which must be denigrated when you decide against them. I think that's a dangerous proposition, because you cannot look at the role of the Supreme Court, the work of the Supreme Court, from perspective of the outcomes. Outcomes of individual cases may be in your favor. Outcomes of individual cases may be against you. And judges are entitled to decide with a sense of independence on a case-by-case basis which side of the balance the dice must be cast. Now, you are entitled to criticize courts for the ultimate outcome, for inconsistency of legal doctrine or an error apparent or whatever. And I'm sure judges have no difficulty about it. But the problem lies when the very same people who see that the court is, say, going towards a particular direction are all willing to criticize it merely because an outcome has gone against you. I think we as a legal profession must have a sense of robust common sense to understand that judges are entitled and must decide on a case-by-case basis, depending on how they assess legal doctrine has to be applied to the facts in that particular situation. So long as we accept that, I think the future of the institution is safeguarded. But I think it's important that we understand that as a legal profession, because judges, more than anybody else and citizens, look up to the members of the bar to support the endeavors of the court. Now, that is really something which leads us to the role of the Advocates on Record Association. The Advocates on Record Association, the SCORA, is in that sense a vital element in the functioning of the Supreme Court. It's a vital element in the Supreme Court's functioning because you have the direct interface with clients who come to you from the states. Our clients speak diverse languages. Our clients belong to diverse regions. Our clients belong to diverse cultures. They belong to diverse religious identities and different identities, whether it's gender or caste or other forms of marginalization. So as the direct interface between clients and the process of justice, the Advocates on Record Association performs a vital role. And that vital role is to enable the AOR to put together the entirety of the grievance of injustice before the court in a comprehensible manner, act as a responsible intermediary between the client and the court. Now, this is something which I think is in danger today of being really challenged. I don't know why that has happened. Maybe one of the reasons is that the strength of the Advocates on Record has now increased so much that the group of Advocates on Record is no longer a small body of people, but is now expanding very rapidly. Now, this expansion in the association is not per se a bad thing, because just as the legal profession expands, as the quality of legal education expands, you're bound to have more and more talented young lawyers who will become advocates on record. But my fear is that so long as we maintain standards of quality among the advocates on record, we would have no cause for concern. But if we forget the standards of quality which advocates on record have to maintain, the share in the pie, namely the available litigation which is being filed in the Supreme Court, will tend to be distributed thinly amongst an ever-increasing quantum of advocates on record. And if that happens, then the real problem is, how do you then distinguish between the Advocates on Record Association with the wider bar outside? Therefore, I think this is something which SCORA as an organization, and I have been having these conversations with the office bearers of SCORA. This has not come out of my own head. I've been having constant conversations with the members of the executive of SCORA, both in the present committee, which consists of very serious advocates on record. In fact, one reflection of the fact that the present committee is of serious advocates on record is that such a conference has been put together. And I've noticed that there is a change in the level of dialogue between the Chief Justice and the executive. The advocates on record come to you with grievances. When I was Chief Justice of the Allahabad High Court, the advocates would rush to me in the evening with a very serious complaint on how a judge said something to a lawyer and we are threatening to go on strike, and they would be all agitated. So I would always begin with a cup of tea and some snacks, and they would say, "Sir, but you have to resolve this first. Iske baare mein kya karna hai?" So I would say, "Dushmani aapki chai ke saath to nahi hai na." So we would first have a little conversation, get tempers cooled down, and then talk about some of the serious stuff. So likewise in the Supreme Court over the last 2 years, I've been meeting constantly with members of the SCBA, members of SCORA. But what I find now is that a lot of issues which we discuss are serious issues concerning the bar, which is very critical because that's how we can find solutions. And it has been my endeavor over the last 2 years to find solutions to the problems which we confront of advocates on record. One of the things which we have done in the registry, and something which I must share with all of you, is to bring together a team in the registry of distinguished and very competent judicial officers from across the country. Because I do believe that it is essential for the Chief Justice of India to have a diverse team of senior district judges who come on deputation to the registry, both men and women. And we have tried to bring about this diversity in the Supreme Court. Because the Supreme Court is not a Supreme Court of Tilak Marg. It's the Supreme Court who represents the entirety of the nation. Just as, all my colleagues, if you look at the profile of the present constitution of the Supreme Court, it reflects the diversity of the nation. Colleagues from the Northeast, colleagues from the South, colleagues from the West, colleagues from the North, colleagues from the heartland of India. Likewise, in the administrative work of the Supreme Court, it's important that we reflect this diversity of the nation so that the administrative input which comes into the Supreme Court matches the diversity of the nation. And I see that in the work which we do, the advocates on record, you will have them here itself. Mr. Vipin Nair, Amit Sharma, Nikhil, your office bearers are from different parts of the country. Now, the language which they speak, obviously I'm not talking about English or Hindi, the language which they speak in terms of their cultural language, their cultural identities is very distinct. And in our association or engagement or interface with the advocates on record and the Supreme Court bar, we as judges and administrators have to be cognizant of the fact that we are dealing with a multicultural, multilingual, multi-religious, multi-caste identity of the Indian bar in the Supreme Court. And that, to my mind, is the strength of the bar in the Supreme Court. That the bar in the Supreme Court represents the complete diversity of the nation. So when we designated senior counsel, and I know that we have been subject to some critique on the number of senior counsel who were designated. Someone told me just the other day that, Chief Justice, do you know that many of the senior counsel who you designated are still to gather work? But I said the purpose of this broad designation of senior counsel was very different. The idea of designating senior counsel must also be to convey the impression that in designating seniors, we are creating a platform for others to excel. Obviously, you designate people who have had some basic level of work and more than the basic level of work. But by creating this platform, we are allowing our bar to prosper. Not all of them will obviously do brilliantly at the bar 10 years or 5 years or 15 years down the line, but that's the same as appointing judges. Not every judge you appoint to the district judiciary or to the High Court achieves the same level of excellence. But all of them, by virtue of their experience, bring a certain degree of accumulated understanding about the law and society. Likewise, the effort in designating many of the seniors has been to allow the bar to understand that the Supreme Court bar, when it wants to aspire for improvement or advancement or change in their professional existence, should not be confronted with this barrier that, this is somewhere a closed or a clique of people, so that the designation would be conferred only on a certain closed group of people. And the reason which I thought we must put across to the nation is that people across the nation, particularly women lawyers, because it's important that we recognize the important role which women lawyers are playing in the legal profession today. And by creating this platform of opportunity for young lawyers, we'll be allowing our bar to progress in the mid to long run. And I've seen personally how lawyers who were advocates on record until just a month ago, and they're given a small brief as senior counsel, the early briefs will maybe small briefs, you realize that there is a complete transformation in the way they argue cases in the court, because they are also under the great awe and the great responsibility of the fact that they are now designated as seniors by the Supreme Court. Why do judges behave? Judges behave, of course, because they are expected to behave in accordance with law and the Constitution, to be fair, to be objective. But judges also perform in a certain manner because of peer pressure. All of us are constantly looking at each other and the work which we do. When we meet, we discuss, we have our lunches, we are in conversation. Likewise, we are under scrutiny of wider society. In the work which we do, we are constantly under scrutiny by all these social media websites, by the press. We are being constantly assessed in the bar rooms over cups of coffee, sometimes fairly, sometimes unfairly. But likewise, the reason why people in a profession like ours have an aspiration for betterment is because we belong to this fraternity, which is a fraternity which produces an internal discipline and which provides an expectation of better behavior and change and better standards. And therefore, I do believe that in our effort in the last several years, we have tried to create these spaces of opportunity for young lawyers. And I do hope that these spaces for opportunity for young lawyers would be taken up in a very large measure by them. You know, another thing which I thought I must, of course, mention is we have placed a great deal of importance on regional languages in the work which we have been doing as judges of the Supreme Court. In fact, I personally try and speak to any client in person who speaks a language which I understand or know, to try and speak in that language. And the reason for it is that we represent a nation which, as I said, is a nation of diverse linguistic and other cultures. We have translated, as you know, the judgments of the Supreme Court into all Indian regional languages. There are about 37,000 judgments of the Supreme Court since independence. We floated the digital SCR, which is now, if those of you who have not used the digital SCR, please use the digital SCR because it's a free resource, head noted, and SCRs are up to date now completely. And I thought that we should translate all these 37,000 judgments using machine learning, with all AI-assisted machine learning tools. We are using large language models, which are, of course, then verified by human agencies. We have retired district judges who actually look at the translation. More on that a little later on Law and Humor. Because when we say leave granted, the machine learning always says, Avkash prapt ho gaya. So you have to train it to say, it's not Avkash prapt ho gaya, but it's leave granted to appeal. But all the 37,000 judgments of the Supreme Court have now been translated into Hindi. Now, the advantage of translating these judgments into Hindi is you have judges today who have never spoken English. Judges even of the high courts, when they came from the district judiciary, I had colleagues in the Allahabad High Court and I asked them, "Aap Angrezi mein likhte hi nahi hai?" And they would say, "Sir, when I was a district judge, I was a member of the district judiciary, I didn't have an English stenographer. So how would I write an English order?" Now, if the district judiciary is predominantly a regional language judiciary, and most of the judgments or all of the judgments of the Supreme Court are only in English, we are distancing ourselves from the process of dispensation of justice at the trial level. And we have therefore, and that's a very serious cause for concern. So a judgment of the Supreme Court laying down what should be the yardstick for the grant of bail in a PMLA matter, if that does not reach out to the judges and the lawyers in the special courts, how do you expect them to do justice? So therefore, we have to reach out in languages which citizens, lawyers and judges in the districts understand. And this is not just confined to Hindi. I'd like to share that. We have been translating judgments into Tamil, every language which is recognized by the 8th schedule to the Constitution. In fact, the Honorable President of India, when I was calling on her, and we were in a conversation, said that, Chief Justice, do you know this, that could you translate also judgments into Santali? She said, at least translate those judgments which have a bearing on tribal rights, so that tribals understand that these are the rights which are recognized by the Supreme Court in their favor. It may be in regard to land revenue, it may be in regard to small offenses on which the President has been speaking a lot. And therefore, this mission, I believe, of the Supreme Court is a mission to, in that sense, take the court to the homes and hearts of the people. The Advocates on Record Association has, over the years, done amazing work in our bar. We know of so many advocates on record who became senior counsel. Some of the earlier advocates on record, like Mr. P.P. Rai, I was just talking to Vipin, who truly made that transition from being advocates on record to becoming senior counsel. And they became senior counsel in truth and substance. In Dr. Chitle's chamber, when we were young juniors, we used to have lunch. It was a chamber of Raju Ramchandran, Mukul Mudgal. Mukul went on to become a member of the Judiciary. Raju became a senior. And they had this concept of seniors in the A category and seniors in the B category. So one day I asked them, how do you distinguish between seniors in the A category and seniors in the B category? So, particularly Mukul had this very acerbic sense of humor. So he says seniors in the A category are advocates on record who have become seniors who do not have a cyclostyling machine in their office. Seniors in the B category have a cyclostyling machine in those days in their office, which meant that they were basically doing the work of advocates on record, but they had become designated as seniors. Now, that's again a process of bridging the change from becoming an advocate on record into becoming a senior arguing counsel. It's obviously when you stop filing your own matters through your own juniors, the wider bar will have the confidence to brief you. Because if clients in the bar at large believe that you are still filing your own matters through your own juniors, obviously people are a little reluctant to give you a brief because tomorrow the client may go to you directly. But that's a change which everybody makes over a profession. The Advocates on Record examination is, I think, a key. One of the concerns which I do believe we have to answer is that the coaching class environment has also permeated the Advocates on Record examination, which means that we are only going to have people who will be taught how to crack the examination without having, the sense of values, the ethics, the responsibility to the court of what you can do and you cannot do in a court, only in search of a positive order. Now, how do we really deal with this? And this is something which I think all of you should be discussing, not necessarily in the sessions, but in the longer run, which is how do we ensure that the new entrants to this group of very select professionals in the Supreme Court continues to possess the values which an advocate on record must have. And there I believe that the seniors, and so many of them are here, Mr. Rakesh Dwivedi, Anupam is here, Neeraj is here, and so many of you are, Dhruv is here, so many of you are, the younger seniors are all here, Swarupma and Menaka, and so many of you, Aishwarya. What I would request, and Guru is there, of course, so many of you, I may have missed out some names, please forgive me. I think you need to sit down and provide for a continuing legal education on values which younger members of the bar will have. Back in the 80s, when I joined the bar was relatively a smaller space where everybody knew everybody else. People could imbibe so much from a daily contact with senior counsel. So when somebody like Soli or somebody like Mr. Fali Nariman spoke, they would be surrounded by 10 or 12 lawyers constantly who would be imbibing. Now, our bar has grown very large. And that's a product of the changing times, because more and more good people are coming into the legal profession. When I joined the legal profession, you came into the legal profession because there was nothing else to do. Middle class parents would want to send their children into medicine, or they would want to send them into engineering. If you had nothing else to do, you came into law. Not everybody was like that. Many people came into the law as a matter of first choice. But a lot of people came into the law because they just sauntered into a court. I remember we were having a conversation when I was a young law student in the Campus Law Center in Delhi University, when a friend came and asked me, and in the Campus Law Center in those days, you always introduced yourself by your roll number. And the typical way to introduce yourself was to say, myself, roll number 965. You never introduce yourself by name. So one of my colleagues came to me and said, he says to me, "Tu karega kya?" So I said, "Wakalat karenge." So इस पर करेगा क्या लाइफ में? So I said, वकालत करेंगे. But कमाई कैसे होगी? So how would you earn money? For Sister Sapna, my friend asked me in the law college, what will you do in life? So I said, I want to be a lawyer. But he said, what will you actually do in life? So I said, I'll be a lawyer. So how will you earn your income? So I said, from the bar. So he put his arm around me and said, look, I have to put a little bit of common sense in you. I'll translate it to you in English because, for Sister Sapna's benefit. He put his arm around me and says, look, I have to put a little bit of common sense in you. He says, look, your father is the Chief Justice of India. This is your time. Please get a gas dealership or a petroleum retail outlet. And he says, you will get a regular source of income. And thereafter, you can also do a little bit of lawyering on the side. Now, I never got a gas dealership or a retail petroleum outlet. Had I even mentioned it to my rather strict father, he would have thrown me out of the house. In fact, he insisted. He went to the Allahabad High Court. There was a big problem with lawyers feeling that too many judges' children were entering the bar. And while addressing the bar, the High Court of Judicature of Allahabad, my father got up and said, my son will never enter the bar so long as I am a judge. And he never asked me whether, I'd abide by that diktat. But in those days, when parents said something, you had to accept it. When parents said, we have to go tomorrow to this particular place on a holiday, we accepted it because that was the sense of authority. I'm not sure how many of you in the audience have that sense of authority over your children. But, that was a sense of authority. And when we came back, so many of his colleagues said, but did you consult your family over this? And he said, no, but I feel that, my son shouldn't join the bar so long as I'm the Chief Justice of India, because every court in the country is a court from which an appeal lies to me. And there was a Chief Justice in Jammu and Kashmir whose child, whose son or daughter used to practice before the High Court. And it was alleged that, there was a district judge who would get up when that Chief Justice's son or daughter entered the court and get up and say namaste. So the then Chief Justice of India asked that judge that, brother, I believe that, when your son appears in that court, I believe the district judge gets up and says namaste. To which the judge said, well, what do I do if the district judge gets up and says namaste to my child? Well, you can do a lot. And I think there is a lot which we can do to create that sense of understanding of wider society, that we are an equal opportunity court and bar. One last thing, and I think I'll be then done because I have to also move on. You have next sessions. We have law clerks whom we recruit in the Supreme Court of India, and they do some amazing work. My law clerks are now, I'm proud of them because my law clerks have gone to almost the top universities in the world. One of my law clerks, who's a first-generation lawyer from Madurai, she has been nominated as a Fulbright Scholar for the next year. One of my law clerks she went to Harvard Law School. The young Dalit boy who has been a law clerk with me from Lucknow, again went to Harvard. They've been all over the world and they're now working in India as well. I felt that how do we create a space where young people in the legal profession believe that the law can be an equal opportunity employer? Because too very often I used to find that law clerks are recruited by a phone call. And I'm not criticizing anybody. That's the way the system has been run, right? You give a phone call to a colleague you talk to someone and say that, well, will you engage so-and-so's son? And typically, somebody would come from different parts of the country and clerk. I felt that in order to create a sense of confidence in the younger members who are now exiting law colleges, we must provide an equal opportunity to young lawyers or young aspiring lawyers to clerk with Supreme Court judges, because it's an extraordinarily prized position, both in terms of money. We now pay 80,000 rupees for the first year per month and 90,000 rupees for the second year for young law clerks in the Supreme Court. I'm not sure how many seniors pay that kind of money, but at least we do. I put out a white paper during COVID times, which was, of course, not seen by anyone. But when I became Chief Justice of India, I thought this was an ideal opportunity to put into place that white paper. Last year, in fact, last 2 years, we've held the exam. Last year, definitely. We have held the exam in about 20 or 22 centers across India. We've replicated the design of the CLAT, the Common Law and Aptitude Test. So we held that examination in different centers in India. We held the examination in 3 parts. The first part is a multiple choice question paper spread over 3 hours. The second part is drafting a brief based on a mock judgment which we provide. Not a very difficult brief, just 750 words, which you can do in a couple of hours. Third is a research paper, where you're given something which would consist of a jumbled set of legal principles, and you're supposed to just prepare a small research paper for the judge. After doing that, we allow all the young applicants to give their preferences for judges. Because we said that why should they not have the ability, as in, say, medical colleges, to give their preferences, that this is whom I want to work for. You may not get your judge of first preference, but you should at least have that ability to say that. The idea is for us to also climb down from this high pedestal and say that, look, we would like to be with people who want to be with us. And then we have an interview where the judge will actually sit and take people from the list, the merit list which we have prepared. And we used to have 4 law clerks. So I said to my colleagues that, all right, 2 law clerks you can take of your choice. 2 law clerks you must take from the system. But I threw in a carrot and I said, if you take a 3rd law clerk from the competitive system that we have created, I'll allow you 5 law clerks as part of the budget. But this simple things like this, and I think the advocates on record should really think of this in the future. Can we not, in the AORs or in the chambers of senior lawyers, have a more open system of recruiting young people into the profession? This is a subject very close to my heart, which I thought I must dwell on, because that's the only way in which we will ensure that people who are coming into the profession don't have to suffer the kind of hardship which so many young and not so young lawyers of today have had to go through. When we designated seniors and we held the interviews, we asked all the people who were applicants for the process of designation as seniors to sit in the multipurpose hall of the Supreme Court. We had a seating chart as they have at Harvard Law School, where you're graded, by your professors. And we asked everyone to tell us their life story. The Supreme Court judgment requires us to interview lawyers. And I said, you can't sit down and interview lawyers and ask them, what do you mean by an Order 7 Rule 11D application? They were all appearing before us. So we thought, let them tell us their life stories. So we gave them about 5 minutes. Somebody took 7 minutes. Somebody took 10 minutes. Every one of them gave us their life stories. The first round, we began at 3 and ended at 10 o'clock in the night. Now, in the course of their life stories, we realized what the Supreme Court bar, whether AORs or others, really consists of. They gave us moving stories of how they had begun their careers in small districts in India, came to Delhi in search of work, not knowing a senior, not knowing what Supreme Court practice was, came here, one young woman lawyer said that my father said that, well, there's no place for you in the district court in Gorakhpur. So she said, well, where do I go? I want to be a lawyer. So she said, well, I came to Delhi. And then I tried and established myself. So these are stories which are real life stories of the members of our bar. And we as judges are very deeply cognizant of those stories. And therefore, I think there's a great obligation on judges to encourage the members of the bar. There's a great obligation and responsibility on senior and not so senior members of the bar to encourage the future of the profession. And I think we can do a lot to encourage the future of the profession, because it is in the decisions which we will take today, small decisions in incremental matters, which will define the stature of our bar for the future. And that will define the nature of the legal profession for the future. I'm always asked, why is it that you have such few women judges today in our courts, particularly in the high courts and in the Supreme Court? And I always say that the reason why we have few women judges in the Supreme Court today is that the Supreme Court today reflects the demographics of the bar, say 20 years back. Because you have to take people from the talent available at the present point of time in the high courts predominantly. Of course, we have bar judges as well, and we had judges like Sister Indu Malhotra who came from the bar. So if we want to change the demographics of the Supreme Court into a more inclusive, broad-based and diverse bench, we have to take those decisions today. And those decisions will have to be taken by each individual member of the bar, the Advocates on Record Association, the Supreme Court Bar Association, because we are all really members of the same bar. These are appellations. We have associations. But we have to take those decisions today, because it is in the ability to take those decisions today that we will lay down the future for a more even and dispersed profession. The Bar Council of India has taken a decision recommending that some minimum scales of pay should be made available for lawyers. I'm sure that members of the bar will take that very seriously and ensure that we pay something which is commensurate with dignity. And the last point which I'd like to say is that I think as seniors, we shouldn't look at young lawyers who enter our courts as somebody who has come to learn from us. Of course, they come and learn from us. They wouldn't know how to draft maybe a good synopsis. They may not know how to draft the good grounds in a second appeal. What's the distinction between a civil revision and a first appeal and a second appeal? That's what the senior has to do. But in terms of their understanding of life, I find that when youngsters collaborate with us, we learn so much from them, from their understanding of life, because they have a pulse for society today. And as we grow higher, I'm not just talking of judges who are isolated by the very nature of our office, but as we grow higher, senior advocates, you have no time to look at, the shopkeeper, because then you are dealing with clients of a much higher order. But it is from the youngsters who collaborate with us in our offices that we learn the pulse of Indian society. So we must change our perception that people who come to work for us are coming to learn from us. They're coming to be mentored by us. But equally, we learn as much from them. So I think the future of the profession is bright. I wish I had a prepared text, which I did, and which was all of 7 pages long, which I would have finished in exactly 14 and a half minutes. I took much more, but that's what happens when you give the mic to a judge who does not have a prepared speech. On a lighter vein, we had a judge, I will know no names and no high court to be mentioned, who used to love the mic. And as young lawyers, we all called his lordship Michael as the first name. I hope you will not call me Michael. Thank you.